my name is Amanda Stedman, and welcome to BDBF's series of mini webinars on women's health and wellbeing at work in honour of International Women's Day 2025. In today's webinar, I will be looking at the issue of menstrual health at work. Did you know that in June 2023, Spain became the first European country to grant paid menstrual leave rights to workers? Workers were granted the right to take between 3 to 5 days of leave for severe period pain each month. At the time, the Spanish Equality Minister said the new law represented an historic day for feminist progress, which meant there would be no more making your period invisible, taking pills in order to work, or dying in pain while pretending that nothing is wrong. Here in the UK, the charities Bloody Good Period and Endometriosis UK have called for the UK to follow Spain's lead and introduce ring-fenced menstrual leave for women experiencing menstrual health difficulties. Indeed, a recent survey conducted by YouGov revealed that many women in the UK are adversely affected by their menstrual cycles at work. 1 in 4 women said that they had regularly experienced period pains that affected their ability to work. Yet there is currently no legal requirement for UK employers to offer menstrual leave. So currently, if a UK employee wishes to take leave in connection with their menstrual cycle, it must be taken as ordinary sick leave. But in practice, very few women do this. Only 1 in 7 of the women who said that they regularly experienced period pains affecting their ability to work tended to take time off sick. The vast majority either never did so or did so only rarely. And where sick leave was taken, the majority felt unable to tell their employer the true reason for the absence. And I think that reluctance is likely to stem from various factors, including the stigma around discussing such matters with colleagues. Now, although there is no express right to menstrual leave, there are some other legal protections available to women who are mistreated at work in connection with their menstrual cycle. Employees with 2 or more years' service are protected from unfair dismissal, and this requires an employer to identify a fair reason for the dismissal and to act reasonably, including by following a fair process before the dismissal takes place. A failure to take into account an employee's representations about the impact of her menstrual health problems on, say, her performance, attendance, or conduct may mean that the dismissal is unfair. In addition, there is protection available under the Equality Act. For example, if an employee accrued a large amount of sickness absence and this triggered disciplinary action, that could amount to indirect sex discrimination. In such circumstances, the employee could argue that the apparently neutral practice of disciplining staff who accrue too much sickness absence causes a particular disadvantage to women who are more likely to take a higher amount of sickness absence as a result of their menstrual cycle. To justify such a practice, the employer would need to show that the practice was targeted at the pursuit of a legitimate aim, such as securing good levels of attendance from staff, but also that the practice was a proportionate means of achieving that aim, and that is often where employers will trip up. Further, if an employee's menstrual difficulties are severe or are related to an underlying health condition, such as endometriosis or polycystic ovary syndrome, then she may qualify for disability protection under the Equality Act. This would mean that any negative treatment connected to menstrual-related absence could potentially amount to indirect disability discrimination or discrimination arising from a disability. And in addition, the employer may come under a duty to make reasonable adjustments for such an employee. A failure to do so gives rise to a separate cause of action. So, for example, in the case of an employee suffering with painful periods, this might mean permitting her to work flexible hours and or to work from home at short notice, when she is feeling unwell. Now, these kinds of issues have already been considered by the UK tribunals, and I'll just give you a couple of quick examples. In the case of Gare against Oakland Homes No. 2 Limited, Mrs. Gare suffered from stage 4 endometriosis, which meant that she suffered with severe period pain around the time of her period, and that caused her to take time off work. She was dismissed due to her high levels of sickness absence. The Employment Tribunal held that she was disabled by virtue of her endometriosis, and although the dismissal on its face was on the grounds for her sickness absence, the tribunal said that the absence only arose as a consequence of her disability, and that meant the dismissal was discriminatory. In the case of Palawa against Spherical Limited, trading as properties on the market, Ms. Palawa also suffered from endometriosis, which again meant that she suffered from severe period pain around the time of her period. That pain would often leave her bedbound, although she was able to work satisfactorily, but from home. Her employer agreed that she could either take time off work or work from home when she experienced this kind of pain. But later, the employer withdrew all home working arrangements as part of a drive to get staff back to the office after the coronavirus pandemic. Ms. Palawa protested and asked for an adjustment to be made to allow her to continue to work from home in light of her condition. And she also submitted a doctor's note suggesting that working from home should be permitted. But in response, she was dismissed. The tribunal held that Ms. Palawa was disabled by virtue of her endometriosis and that she'd been dismissed because she had asked for an adjustment of home working to be made. That was discriminatory. The tribunal also held the employer had failed to make a reasonable adjustment by not allowing her to work from home. Now, what does the future hold? Well, there are moves to improve the position for UK employees suffering with menstrual health difficulties. The Employment Rights Bill, currently on its passage through Parliament, provides that regulations may be published requiring employers with 250 or more employees to develop and publish equality action plans on an annual basis. Those plans must set out the steps the employer is taking in relation to gender equality. Now, the bill says that will include addressing the gender pay gap and supporting employees going through the menopause. But it is feasible that the list of matters to be covered by an equality action plan will be expanded. And indeed, a non-government amendment to the bill has already been proposed to extend plans to require employers to explain how they will support employees with menstrual health problems and disorders. And that amendment was proposed by a Labour MP, so it does stand some chance of being taken forward. In the meantime, the British Standards Institute and the Chartered Institute of Personnel Development have both produced best practice guidance for employers on managing menstrual health in the workplace. On this slide, I've set out some of the key practical takeaways from the guidance that I've just mentioned. I won't talk through them, but as you can see, there are lots of helpful things that you can do to support your staff, some of which are relatively easy for you to do, such as providing free period products. So why not mark International Women's Day 2025 by setting up a menstrual health support framework for your staff? That's all from me for today. Tune in tomorrow when I will be looking at the topic of reproductive health and reproductive loss.